Our next speaker is Karin Galldin. She was called to the bar in 2005 and founded a feminist-identified legal practice in Ottawa in 2006, offering services to low-income women, survivors of sexual violence, and queers in the areas of human rights, administrative law, and civil litigation. With her colleague Leslie Robertson, she is counsel to prostitutes of Ottawa, Gatineau, Work, Educate, and Resist, POWER. And she provides advice to them on police violence towards and the human rights of the Ottawa sex work community. She also acted as co-counsel in various intervenor applications in Bedford and SWAV on behalf of POWER, Stella and Maggie's. Karin is currently on sabbatical from her practice and giving hard thought to whether a solicitor-client relationship within the currently constituted legal system can truly embody feminist ethics. Please join me in welcoming Karin.
My name is Karin. I want to thank Law Union for inviting me. It is truly a pleasure to be able to share a panel with Terri-Jean and Chanelle and Audrey. So I am here to offer some thoughts about what Bedford changed, what is on the horizon in terms of legal regimes, and what type of social and political context these reforms are occurring in. But before I do that, I'd like to start with a story about my first entry into advocacy, which came in the summer of my first year of law school, which, as you can imagine, is a very exciting opportunity for first-year law students. I was working at a union-side labor firm, and they had provided me with a small claims pretrial on behalf of a woman who was being sued by a man who she had met at work. And in the context of meeting that man at work, he had given her his debit card and said, you know, if you need to take money out from time to time, I understand your personal circumstances may be challenging, go ahead, here's my PIN number, go ahead and take that money out when you need to. Somewhere along the line, this individual decided to sue her. And I was told by the law firm, this is a no-brainer. He gave her his card, he gave her his PIN number, and you're fine. So we go to the pre-trial together, and the judge is really drilling at this guy. Why is this a claim? Why are you even suing her? You gave her your card. You gave her, your PIN number. It sounds like you understood this was all going to happen. And the guy says, but you need to ask her where she works. And the judge turned to my client and said, where do you work? And then said, she's a stripper. And immediately turned, and the focus was on her being a stripper, and immediately there was distrust towards her, and the remainder of that pretrial was about questioning her and what she could have done wrong. So it was a really great lesson for me in terms of advocacy. It certainly was very challenging, but it also left me with an underlying theme that I think you discover as you move towards your law career, which is the extent to which stigma and violence is embedded within our legal system and directed towards marginalized communities. And then, of course, the question is, to what extent are we complicit in that system when we're lawyers that take part in it? So, you received a few introductory remarks about why I'm here. I have acted as co-counsel for Maggie's, Stella, and POWER before the Ontario Court of Appeal, and with intervenor applications to the Supreme Court of Canada with Leslie Robertson and with the amazing Cynthia Peterson, who you'll hear from tomorrow, and Charlene Wiseman of Sackville Blatt Mitchell. Also do a lot of support with POWER in Ottawa to mobilize against ongoing and very targeted police violence towards sex workers. And I have also worked with individual sex workers as clients in my day-to-day practice. I work with sex workers because, first of all, they are my friends. Secondly, because I believe sex work is work. Thirdly, because I believe that our society's inability to acknowledge sex work as work is indicative of the way in which we view women's sexual autonomy as deviant, threatening, and harmful. And finally, I do this work because sex workers are being very much harmed by laws and stigmatization and are dying. So let me offer a few comments about what Bedford has changed. Being a lawyer, I'm a bit of a pedant about sort of how things happen. So I'm just going to unpack the decision a little bit for those of you that aren't familiar with it. So first of all, a unanimous decision from the Supreme Court. So a really resounding message from the Supreme Court that the current regime is entirely inappropriate. And the starting point for the Supreme Court was that it is not a crime to sell sex for money. And with that as the starting premise, it was very difficult to find that there had not been a charter breach. The criminal code prohibitions, the Supreme Court said, do not merely impose conditions on how sex workers operate, they impose dangerous conditions on a legal transaction. So the three provisions at issue were examined for their impact on Section 7 rights, specifically the rights of an individual's security of the person. Section 210 was the first provision that was challenged, which prohibited the operation of common body houses, defined as any place under the law that is used regularly for the purpose of prostitution. This provision, as you likely know, prevents the sex workers from working out of fixed indoor locations such as brothels or their own home. The Supreme Court said that the impact of these laws was grossly disproportionate because it prevented fixed indoor locations for sex workers, interfered with their ability to undertake preventative health practices, and prevented a resort by sex workers to safe houses. For example, a location called Grandma's House that had been established in Vancouver around the time that there were, a growing understanding of women disappearing. And in so doing, the Supreme Court commented that Parliament has the power to regulate against nuisances, as they had claimed their legislative objective to be, but not at the cost of the health, safety, and lives of sex workers. A law that prevents sex workers from resorting to a safe haven, such as Grandma's House, is a law that has lost sight of its purpose. Section 212 was the second provision at issue. This section prohibited living on the avails of prostitution, preventing anyone, including to, but not limited to pimps, from profiting from another's sex work. It applied to a variety of relationships in which someone else is viewed as having a vested financial interest in someone else's work. Anyone who is hired by a sex worker to assist them with their work runs the risk of being captured by this provision. The Supreme Court said that this provision was overbroad because it prevented security-enhancing safeguards. So Power, Maggie's, and Stella, in their intervenor application, which was unsuccessful before the Supreme Court hearing, had really wanted to attack this particular provision because it had been upheld, it had been read down, but the Ontario Court of Appeal said there's some merit to it, let's keep some of it on the books. And they really wanted to emphasize to the Supreme Court that the effect of this provision was really to say that sex workers can't be trusted to choose their own relationships, which is at odds with the other legal constructions of sex workers as your sort of, your evil, woman who's going to draw all sorts of criminal activity towards her in the neighborhood and sort of eat your children. But when it came to this provision, it's a very, very patronizing embodiment of a sex worker who really, doesn't know and is vulnerable to any type of manipulation. And certainly this kind of prohibition on third-party relationships is not one that's placed on workers in any other legal occupation. But despite the fact that our clients weren't able to make that argument for the Supreme Court, they certainly understood it nonetheless. So that was a good thing. Final provision, which was at issue in Bedford, is of course the communication provision, which, if you will recall, was the provision that was upheld in a split decision before the Court of Appeal. This was the provision that prohibits communicating for the purposes of sex work in public, the most applied criminal provision, and the one that impacts sex workers who work on the street. It means, of course, that sex workers who work on the street must do so in circumstances that expose them to the risk of violence. They have to work in dark, remote places, so they do not capture police attention. They cannot work in concert with other sex workers, and they must conduct their communications quickly so as not to attract police attention. There's a real impediment to screening for intoxication and other potential risk factors, obtaining key personal information from clients, and telling other sex workers where they are working. The Supreme Court, again, had no problem understanding that this provision created displacement of sex workers to unsafe locations, and also prevented them from doing appropriate screening. Found in general that it was grossly disproportionate to its legislative objective. They also spoke directly to the Court of Appeal's finding on the communication provision. So 3 of our judges in the Court of Appeal, there had been a 5-member panel, had said, you know, we're not really convinced that this communication plays a great role in sex workers' exercise of their liberty and their safety. And the reason is because sex workers are too fucked up, basically, to screen. And they did their laundry list of how it is that they believe sex workers to be too fucked up. You know, addiction, drug usage, poverty. And the Supreme Court had no traction for that argument, and said that may be true for one person, but more importantly, on the reverse side of that, if the screening, the Supreme Court said, could have prevented one sex worker from jumping into Robert Picton's car, the severity of the harmful effects of that law is established. So in terms of other highlights from the decision, there had been a really strong sentiment expressed by the government over time that you can't link the violence that sex workers experience to the actual criminal code provisions. Rather, the connection that these laws create is not direct. The connection is negated by sex workers choosing to engage in what the government characterized as risky commercial activity, or the violence is created by third parties, which the government insisted were Johns, which of course sex workers would tell you those are not their Johns, those are predators. And the Supreme Court said, no, we don't buy that at all. And they said, certainly some sex workers choose, but some sex workers enter the profession by less meaningful choice, which I think is as close as we're going to get to the Supreme Court acknowledging the feminization of poverty, at least in that decision. And they also commented that sex work is not illegal. So they offered a really, I thought, cute analogy in that they said, the causal connection is whether the impugned laws make this lawful activity more dangerous. An analogy could be drawn to a law preventing a cyclist from wearing a helmet. That the cyclist chooses to ride her bike does not diminish the causal role of the law in making that activity riskier. So on remedy, on this victory, this success, there was a declaration of invalidity for those 3 provisions, but that declaration has actually been suspended for a year. So there's existing confusion. You might have even noticed they use sort of interchangeable past and present tense. It's been left to sort of the discretion of the crowns in various jurisdictions to decide whether they're going to continue enforcing these laws or not in the year in which our federal government has to come up with an alternative. The alternative was characterized by the Supreme Court as that of how to regulate sex work. It was very clear towards the end of the judgment, we are not talking about a criminal activity, we're talking about regulating a lawful occupation. I'm going to offer a few other comments about successes from Bedford, and I would like to say that apart from this immense change in the law that Terri-Jean has directed, we also have had a really amazing growth of community. Sex workers put themselves at the center of crafting advocacy strategies. Sex workers, told their counsel and told counsel for other groups what language to use, and were very mindful of what strategies could be advanced before the Supreme Court that left no one behind. There was also a growth of allyship, as you saw a series of supportive interveners appear before the Supreme Court. Aboriginal Legal Services, the Pivot Swath Pace Coalition out of Vancouver, Women's Studies Department out of Vancouver, out of Montreal, Simone de Beauvoir Institute, the BC Civil Liberties Association, and your coalition of the HIV/AIDS Legal Network, the BC Centre for Excellence in HIV/AIDS, and HALCO, here of Toronto. You also had a fair bit of discourse around what was a feminist position to take in Bedford, and there were a series of groups that had appeared before the Ontario Court of Appeal and identified themselves as advocating for an asymmetrical solution and characterizing themselves as a feminist coalition. And leading up to the Supreme Court, you had other women's organizations, again coming out of the violence against women community, saying, we we support decriminalization, and we are also feminists. So you had a real enriching of discourse around that and of community building. So what's next? What's next for sex work in Canada? That's why you're here. That's what you're curious about. The immediate priority, what I hear from my clients, is to prevent the Nordic/Swedish model, which our conservative government is shopping around because it won't protect sex workers nor reduce stigma and violence against them. I'm just going to offer a little bit of the legal reasoning behind the Swedish model, and I would like to say that, an ongoing joke I have with my friends is that I am Swedish, which means that this is the one Swedish thing I don't like. Talk to me about ABBA afterwards. It's forever, forever. Okay, so the Swedish model, which is very much, you will hear about it a lot. It's very palatable for our conservative government who would like to repackage themselves as human rights defenders increasingly. The 1998 Women's Peace Law in Sweden is intended to eradicate sex work entirely, and the aim is that of gender equality. In Sweden, the legislators passed this law believing that all sex work is a form of male violence against women, which of course erases the lived realities of a great number of trans sex workers and men who have sex with men, but despite that, we stick to that binary when we talk about this model. Criminalizes those who purchase sex. Anyone who obtains or attempts to obtain what is characterized as a casual sexual relation in exchange for payment under the law. There are also related laws. So again, it's not the sex worker that is criminalized, it is the client. There are related laws that criminalize those who, quote unquote, improperly financially exploit sex work, and also who promote sex work by permitting individuals to use premises for sex work and working with others. So the impact of that, one of those latter provisions, is that sex workers are criminalized if they work indoors, or their relations are criminalized for working indoors, and the only safe way to work indoors is to work in your own home. There's a lot of voices from Sweden that are telling us that this model is unacceptable and that it continues violence against sex workers. Sex workers who are indoors continue to be criminalized. Sex workers who work outdoors are criminalized, are made unsafe by the conditions in which they can find and meet clients, and feel themselves further estranged from the community that is meant to be supporting them. Sex workers are unable to work or live with others, including their partners, since it is illegal to share in any income derived from sex work. And the Swedish government has actually acknowledged that they understand that this then makes it harder for sex workers to access and maintain housing, but that's okay as we move towards this new normativity of eradicating sex work. There is no differentiation in Sweden in terms of what is an exploitative relationship, which is again the very concern that Power magazine Stella raised about the parallel provision here in Canada. And police continue to harass sex workers in order to criminalize their clients. So the real takeaway from this is that also sex workers are technically allowed to sell sex in Sweden. Because the law criminalizes the purchaser of those services, the transaction remains illegal. There's an excellent article that was written recently by Sandra Chu and Rebecca Rose, and I'm happy to pass on that citation if you'd like. They have done a really great job unpacking how they believe that a Nordic model in Canada could still be a breach of charter rights, but they also raise some questions about whether gender equality can be upheld as a legitimate legislative objective at all, given what we've heard from the Supreme Court of Canada, that certain standards of public and sexual morality cannot underlie criminal sanctions. Rather, they must be values that Canadian society as a whole has endorsed. There's an alternative model that is being supported by sex work organizers at the national level, and that is the New Zealand model, which operates from a very different paradigm. There are some basic criminal protections in regards to sexual services from people under the age of 18, or compelling a person to provide commercial sexual services. There are also labor guarantees within that New Zealand regime, and very positive outcomes that the government had committed to looking at after the 10 years of that law being in operation. I'm going to let Chanelle speak to it in more detail, or I can answer some questions about it. So we have these different models that are being debated at the national level, but I think that it's important to recognize that they are being talked about within a climate that still problematizes sex work and problematizes sex workers. First of all, in terms of this new regime, there is no meaningful consultation with sex workers in terms of what sex workers would like to see and what could increase their safety. There's continuing state violence against sex workers. You have a huge conflation of sex work with human trafficking. You have growing policing of poor people. You have a lot of not in my backyardism and a growing sentiment of resistance to harm reduction. There's a phenomenon that has also occurred that was characterized as a national initiative that, again, still problematizes sex work, in which there were cross-country raids of sex workers in their home, in which police officers in Ottawa and in Toronto and other cities called up sex workers and arranged a visit as a John, showed up at the door, rang the doorbell, and said, "I'm a cop, let me inside, and by the way, these 4 guys are also here with me as well." And of course, there's that tension that anyone experiences in an encounter with the police around if I comply, will I be treated somewhat respectfully? If I don't comply, what are the repercussions? And so what you had were a series of absolutely non-charter compliant searches of people's homes under the guise of looking for signs of human trafficking. And the Ottawa police in Ottawa said, well, we didn't find any human traffickers, but we did find a few girls who were 18 years old and involved in sex work, and 19 years old. So it's very much part of the discourse around, again, conflating human trafficking and sex work. This is particularly problematic that the police is undertaking this initiative, given the confusion that sex workers still feel around what are the current laws and what am I going to be criminalized for? And also the question of, what is the damage that a sex worker experiences when a police, trespasses into her home and uses basically an abuse of his office to do so. And finally, who's prepared to sue the police? So with that, I will just offer a few last comments about what it is that a lawyer can do and where it is that we need to situate ourselves when we talk about sex work advocacy going into the future. What I hope to convey is that sex work advocacy is not simply about decrim. It's about moving sex work towards a politic in which we view it as labor, in which we view it as a human rights issue, and in which we recognize the sort of various cobwebs that are created around sex workers by criminalization and by stigmatization that, again, continue to divide them and their community. So at the heart of sex work advocacy is putting sex workers' experiences first, wherever the worker is situated. There is no one single narrative of sex work, and there is no one good narrative of sex work. So we need to keep that in mind, and we need to remind ourselves that we don't simply work with, the people whose narratives are easiest for us to understand. Sex work advocacy is at the forefront of so many important things in Canada today. It encompasses women, queers, and trans people's experiences of poverty. It encompasses racism, sexism, classism, homophobia, ableism, and whorephobia. It encompasses harm reduction in so many forms and against so much resistance. It involves the agency of young people involved and engaged in sex work. It involves the historical and continuing colonial violence against Indigenous women. It involves systematized violence by police and other state agents, and stigmatized labor. So if you can listen to that list and you can start making some of the connections about where the work is to be done, then those are conversations that you can be having with people in the sex work community, and so you should. The future of sex work is not simply about what model the state adopts next. It is about transforming the way sex work is viewed, respecting the radical and brave work that sex workers do in their community, for each other, and for themselves, and reconceptualizing body work as labor. In terms of the lawyer and the advocate, the future of sex work challenges us to do more and to do things differently. Sex work clients are to define what success means for them in the legal realm, particularly given the politicized environment around sex work, the potential cost of identifying oneself as a sex worker, and understanding what safety truly means for all members of the sex working community. Sex workers put themselves in an entirely vulnerable position when they identify themselves in complaints against the police. They also, as a group, put themselves in a politically very precarious place when they advocate and when they are funded by various sources. And finally, there's the question of how do we make sure no one is left behind? Sex work clients are to locate themselves at the center of legal advocacy, especially after a long history of their being objectified and diminished by legal actors. And I rest on the juxtaposition that we have between the communication provision and the prohibition on sex workers being able to communicate about how and what it is that they're going to do with their bodies, and the really firm and growing case law out of the Supreme Court of Canada that talks about consent to sexual activity as being informed, sexually specific, and contemporaneous. And I do not understand how you can reconcile those two concepts. The role of the lawyer is to listen, to learn, to understand the multiple and varied sources of oppression, and to empower sex workers so that their voices are amplified, not co-opted. It's also about demanding a better discourse from our peers, our colleagues, and our friends. So it's about no more horror-phobic conversations, no more anti-sex work rhetoric in law schools. That, in particular, I think we can do a lot better on asking for from our academic environments. And finally, no more pretending that people's lives aren't seriously and irrevocably affected by the criminalization of sex work. Sex workers are our friends, our community members. So I think the role of the lawyer into the future in supporting sex work reform is to say, what is my role in supporting a future that puts sex workers first? In my office, I have a number of posters around because they make me happy. And Power, in particular, has a number of really wonderful graphics around sex work being work and sex worker rights being human rights. And I had a client come in to see me, and that client, Carol, has lived in a rural community in the Ottawa Valley her entire life as a woman of color, who has also been a sex worker her whole adult life. And I hadn't known or understood the extent to which she had connected with supports, but she came into my office to talk to me about something else, probably around the ages of 50 or 55, and she looked up at the wall and she said, "Oh, sex work is work." And she said, "Oh," she said, I don't know if I'd ever thought about it that way." And I think that to me really spoke to the choice that we can make to extend small gestures in our daily lives that indicate to people that they are part of our community and that we are keen to understand and support their experiences. So I leave it to this audience to think to yourselves, what are the large and small ways in which you yourself can support the amazing things that are going to happen in the future with the sex work community in Canada?